Welcome everyone to our webinar on ensuring legal compliance for your New Zealand franchise. My name is Rebecca Nilsen. I'm a Senior Associate in LegalVision's New Zealand commercial team, and I'm joined today by my colleague Corinne Whelan, who is a practice leader in our franchising team. Before we begin, there's a couple of quick housekeeping items to go through. You will receive the recording and slides in your email, so please don't panic as you're going through, and feel free to submit your questions in the chat box. We will try and get to as many questions as possible at the end. And then after we're finished, please complete the feedback survey after the webinar. It helps us make sure that the content that we provide to you is as high quality as possible moving forward. For all our attendees today, you're eligible to receive a free consultation with us to discuss how we can help you with your contracts and any of your legal needs. To request your free consultation, provide us with your contact details in the survey that appears at the end of this webinar. So today we are going to be discussing franchising, and that's going to be at a really high level around some of the things that you need to be thinking about if you're going to be commencing a franchising business, as well as some of the commercial considerations as we go through it. The agenda on this slide does outline roughly what we're going to be talking about, but we'll guide you through that process today. At the end of the webinar, we'll go through your questions, so please submit them through the chat function and we'll answer them at the end. I'll hand over to Corinne now to get us started about talking about legally compliant franchise documentation.
Thanks, Rebecca. So it's important to keep in mind that when you're starting your franchise journey, you should have all relevant documents in place to protect you and your franchisees contractually. The main documents that you should have to ensure you are legally compliant will include a franchise agreement, which is the contract between you and the franchisee. Now, I think it's really important to say that this should be in writing. Quite often I see people that don't have it in writing, so I would recommend that you have a document and have it all documented on the paperwork. In addition, we normally recommend you have a non-disclosure agreement. Now, this is provided to a franchisee before you give them all your confidential information. So you would have them sign this before giving them a franchise agreement or your operations manual, or even bringing them on board as a franchisee. It's a good way of protecting all of that intellectual property and all of the information that you would be giving them in that vetting process. There are a few other documents that you would normally have, and they will depend on the franchise model itself. So for example, if you are lending money to franchisees, then consider loan documents and security deeds to secure the money that you are effectively lending them. If you're premises-based, consider who is holding the lease. For example, if you're the franchisor and you're going to be holding the lease, then you will need to have the leases and either a license to occupy or a sublease provided by the franchisee, provided to the franchisee. If you want the franchisee to hold the lease, then you would be requiring them to take out the lease, but you might think about having some template lease clauses that they need to negotiate into their leases to protect them and you. In addition, the franchise agreement and lease should always commence at the same time, as this is something that we see that can happen quite often, where there's like a disconnect between the actual term of the lease versus the term of the franchise agreement. In New Zealand, some franchisors do choose to join the relevant industry body for franchising called the Franchise Association of New Zealand, or FANZ for short. While this is not compulsory, some franchisors join FANZ as a member, which comes at a cost, to be held to a higher compliance standard than other franchisors. If you do become a FANZ member, you will have additional compliance obligations, which you should be aware of. This includes preparing a disclosure document, which is updated each year, having certain clauses in your franchise agreement that align with the FANZ code, understanding the FANZ code of practice and code of ethics, and then following certain dispute resolution procedures, which we'll discuss later on. I'll now hand it back to Rebecca to talk a little bit about the other contracts and documents that you need to protect and have.
So when you're starting out, getting your suite of documents ready is really helpful to have at commencement so that you can have a really consistent set of documentation across your franchise. We'll talk about some of these topics a little bit more, so if I'm breezing over them, please don't panic. But some of those things are like employment contracts, which I'll talk about a little bit more, supplier agreements, if you're going to have consistent suppliers that you're going to enforce your franchisees to use, some consumer contracts that you'll require, which we will talk about in a lot more detail because this is something that changes depending on what your business area is in. And then some standard ones like privacy policies, collection notices, website terms and conditions. These are all things that we want to make sure are as standardized as possible before you start rolling out your franchise. Once you have those baseline documents prepared properly, then you need to be mindful of your ongoing compliance obligations regarding your franchisees and your customers, and making sure that you're operating in your network in a really compliant manner. So Corinne can speak a little bit about what that looks like when you're onboarding a franchisee.
Yeah, so once you have the proper documents and templates in place, you'll need to recruit and bring on board franchisees in compliance with relevant laws in New Zealand. The first step to doing this is documenting the relationship between you and the franchisee through that franchise agreement that I mentioned earlier. You should ensure that the franchise agreement includes the commercial terms that have been agreed with the prospective franchisee. If representations or discussions have taken place outside of the contracts, make sure that the franchise agreement contains all of the relevant terms that have been agreed. And this is really important to avoid potential disputes down the line or accusations that you have misled the franchisee into the actual franchise agreement, which would be a breach of New Zealand's consumer laws. When drafting the franchise agreement, be aware of the franchisee's business structure to make sure the right party signs the franchise agreement. If the franchisee has a company, ensure that they have sufficient assets and capital. And if the company is involved, then the franchisee should also have its directors and shareholders personally guarantee its performance obligations under the franchise agreement. This is really important because it protects your financial position. If the franchisee stops paying money to you, for example, you can claim or go after the guarantors. And similarly, it also helps in regard to like the enforcement of restraints or any potential confidentiality breaches. As I mentioned earlier, the non-disclosure agreement is also really crucial when you're onboarding the franchisees. So once you've qualified that franchisee and worked out that you want them to be involved in the business, you should have them sign a non-disclosure agreement before you begin telling them too much detail around the franchising model, providing them with information around your suppliers, giving them your operations manual, or even training them or giving them recipes and access to your systems and process. It's really important to provide the necessary franchise documents and any related agreements that might be relevant, such as those loan agreements I mentioned earlier, at the time of the franchise offer. You don't want to start giving them information and documents piecemeal. It can make it really hard for the franchisee to fully contemplate the offer that you are making. So keep in mind that you've got ongoing obligations to your franchisees. So give them time to digest the documents before asking them to sign. As I alluded to earlier, if you're a FANS member, just make sure you're familiar with the codes to ensure compliance with them when you're recruiting and onboarding the franchisees. For example, there are disclosure requirements when onboarding the franchisees, ensuring that they have to have a cooling off period and understand dispute resolution procedures. With the disclosure document, you need to ensure that that document is up to date and that it's updated every year. So make sure it includes all the necessary information, including financial disclosures. As I mentioned, there is a 14-day disclosure period and a 7-day cooling off period under the FANS Code of Practice. So if you're bringing on board a franchisee and you're a FANS member, ensure that you comply with those required periods to allow the prospective franchisee some time to seek legal advice in relation to the opportunity before they sign the documents. This helps them to understand what they need to do, and obviously keep in mind that if they have and want to exercise that cooling off right we mentioned earlier, make sure you afford them that right if you're a FANS member. So that means that they are allowed to exit the franchise within 7 days of signing if they're not happy with the offer. I'll now pass it back to Rebecca to just talk about the leasing.
Yep. So when we're talking about leasing, it typically goes one of two ways. Either the franchisor decides to hold on to the lease and control the lease, which means that they will either grant their franchisees a license to occupy the premises or they will sublease it to them. There are definite pros and cons to holding on to the lease in your own name or making your franchisee take out a lease in their own name. And that's going to be really particular about your business model, how many premises you're going to be having, how expensive those premises is going to be, and what your risk appetite is like as a franchisor. So it's definitely something to dive into with your advisors to make sure that you get the right structure for you. And it also depends on how much financial backing you have as to whether or not you can really hold that many leases in your own name, or if you're going to need to have your franchisees going ahead and taking it out in their own name. There's no one size fits all, so it's definitely something to talk about so that you can get the right one for you. Corinne is going to have some chat about performance issues.
Yeah. So once you have franchisees on board, it's important to keep in mind the ongoing nature of the relationships with your franchisees. So disputes can arise really easily, especially in the franchising space, if they aren't handled properly. Naturally, you should expect that there may be issues with franchisees during the growth of your network. Just keep in mind that this can be for different reasons. Some things can revolve around, expectations that were sold to the franchisee at the start of the franchise versus when they started operating. It can be misunderstandings around obligations, like who owns the IP or the customers of the franchise business. Sometimes it can be around provision of goods or services, and whether they're providing them consistently with your brand and within your system. And other disputes can often arise just from non-payment of fees or potential changes in financial circumstances of the franchisee. You should take time to consider the franchisee's position if a dispute or something does arise. It may not always be appropriate to take harsh action against the franchisee, so consider whether the issues may be better dealt with in an alternative way. Some ways that we like to recommend or that you should consider are a phone call or an in-person meeting to discuss the matter at hand. So many times we see things just miscommunication and a misunderstanding that if you just pick up the phone and have a call with them, it can easily deal with the issue. Other options are further training on your processes or staff requirements. You could attend to the franchisee's premises, offer some additional training, have a discussion to them or their staff around what you expect. Some other alternatives are auditing the franchisee's business for compliance with your system and processes, or issuing a warning letter if there is some bad behaviour but you don't want to formally breach them. The kind of last resorts that we often go down the path of are issuing them with a formal breach notice, which provides the franchisee with time to rectify the breach before moving to a termination. Or if it's about outstanding money or payments, then a letter of demand for missed payments might be the most appropriate option rather than a formal breach notice. Keep in mind that if you breach the franchisee, the next step is generally that where they do not rectify the breach, then you would be moving to terminate the agreement. So if you don't intend on ever terminating the agreement, then moving forward with a breach notice is probably not the best option. So consider that in the whole scheme of what you're planning on doing, and seek legal advice around what might be the most appropriate given the circumstances. Rebecca is now going to talk a little bit further around those consumer contracts she mentioned earlier and those ongoing obligations under those contracts.
Yeah, so when you're setting out in the business and thinking about your compliance universe, these things that touch our consumers may be more than just written contracts. We also have to think about what kind of licenses do you need to hold, or what kind of licenses do you need your franchisees to hold? What kind of marketing, packaging, behavior when engaging with your customers is required under the law? So it's more than just reviewing what physical contracts we have in place. Sometimes there are minimum standards and some really interesting areas that we have to ensure compliance of depending on your business operational area. So, for example, in food and beverage, there's always alcohol licensing, food permits, how are we storing the food, all of that sort of situation. Real estate, we've got the real estate licensing code, we have guidelines. Cosmetics have actually environmental regulations that we need to be careful of, as well as MedSafe, which is a huge piece of area of compliance that people often have a lot of difficulty with. And then in therapeutic services, it's really important to know that this legislation in New Zealand is changing between now and 2026. So it's going to be a really complicated area to make sure that you're staying compliant in, and something that you need to be able to stay on top of and make sure that your franchisees are staying on top of. Consumer protection laws endure for the entirety of the relationship that you have between yourself and your franchisees, as well as yourself and the end consumer, and your franchisees and the end consumer. So that relationship, if it remains under $250,000 per annum, will be captured by the Fair Trading Act and the Commerce Commission oversight. Which on the next slide we talk about how the Fair Trading Act applies universally. So understanding how the Unfair Trade Act and contract terms and consumer contracts work is really important, because that will transcend all of your documentation that you use in your franchise. And then it's implied into all of your small trade contracts. So it used to be that if you were a business to business, you didn't have to worry about this. But that changed, and now it's implied into absolutely every small business contract, which again is that $250,000 a year. So it's not a small limit, really. The penalties for breaches here are quite significant. For individuals, they're $200,000 per offence, and for businesses, it's $600,000 per offence. So if you have multiple contracts out there, it is possible to end up stacking those sort of penalties really high. The other main area that we always take a look at when we're starting out a franchise is the Commerce Cartels Act. So this actually captures franchise agreements in New Zealand. Internationally, not so much, but the New Zealand law has decided that franchises aren't exempt from it. So things that fall under sort of commerce or cartel prohibitions is things like price fixing, output restriction, or market allocation. So output restriction might be your hours of operation or where you're allowed to sell, and your market allocation is your region. These are very common in franchises. So the way we get around that is to make sure that we've applied to the Commerce Commission for clearance, and that we're acting with our franchise in a collaborative manner. Obviously, your legal advisors can help you with this process, but it's an important step to make sure that you don't accidentally breach this act, because the penalties are up to 10 million, which nobody wants to have in a new fledgling business. Beyond that, the one thing that we have that's going across all of these areas is the duty to act in good faith. That duty to act in good faith is essential for all parties. And if you don't act in good faith in general, it can undermine every single one of your contracts, whether it be with your franchisees or with your consumers or with your suppliers. So making sure that we're across that is critical at all times. And I'm going to pass on to Corinne, who's going to talk about what happens when things need to be terminated.
Yeah, an important thing based on what Rebecca was just saying is that termination of agreements touches on the good faith obligations too. So you do have an obligation of good faith to franchisees even when you are terminating those agreements. So keep that in mind. Look, a major cause of disputes and costs in a franchise network are generally around franchise terminations. It's something that happens quite frequently, more frequently than you'd think. So it's something to be mindful of and to treat very carefully. Normally, the franchise agreement will speak to your termination rights, and usually they will include for you to terminate where a breach is not rectified. Sometimes there will be mutual termination rights, but obviously this is at your discretion. So when you're working with your lawyer, it's really important to make sure that you put in terms in the contract that are, one, fair under the consumer laws, but then two, ensure that you are comfortable with what types of termination rights you and the franchisee have. Keep in mind that the franchise should be for a term. So early termination will mean that the business will need to be dealt with in some way or another. This will involve potentially the transferring of assets, the replacement of franchisees, changes in staff or staff being brought in by you at head office level, or sometimes the entire benefit of the business needing to close down. Termination should be treated delicately, and we recommend you do get legal advice before taking immediate action against franchisees, just to be sure that you are doing it in the most legally compliant way and in accordance with those obligations of good faith and the general consumer law laws in New Zealand. Rebecca's just going to briefly talk about employment law obligations now.
Another delicate area, which is great. So the first step obviously is your employment agreements are essential when you're starting out, which we did talk about briefly at the beginning. If you're going to be taking on a new workforce or establishing a new workforce, or you're expecting your franchisees to establish a new workforce, it's really common to provide them with those template employment agreements so that it's standardized across the franchise. So making sure that those are compliant, that they're workable, that everybody's happy with them is a great first step when it comes to employment. Then we have the more complicated matters, which is if we are going to be considering taking over an existing workforce, perhaps we're talking about that dispute situation Corinne's just discussed. If that's happening, that is technically a restructure, and there are very prescriptive procedures we need to follow to ensure that those employees are not entitled to raise a grievance or a claim against you. So it's always important to make sure you follow the appropriate steps and take some more advice before even commencing that process. Don't do it midway through. That's a recipe for disaster. Then we have some industries that we need to take extra care around because the New Zealand law protects those employees a little more than the average because they've determined that they're more vulnerable to employment changes. So those industries are things like cleaning, laundry, security, roles that are very often changed rapidly. And then we have some things that we have to think about when we're taking over a workforce or setting up a new one, which is WorkSafe compliance, ACC records. All of these things are really important to help set you up to be in the best position possible so that if something does go wrong with your workforce, you have adequate record keeping to show how you've been managing those sort of WorkSafe issues or ACC issues in the past. So we are now going to hand back to Corinne, who's going to talk a little bit more about the dispute.
Yeah, so disputes naturally arise in franchise networks. But they can arise particularly when there's a miscommunication around expectations of the franchisee and what you're expecting from them. So where you find yourself in a dispute with a franchisee, like I mentioned with like the termination obligation, it's best to discuss these issues with the franchisees, determine whether you can reach an amicable resolution. The reason for this is it can be really costly if you do have to go down a formal procedure, go through court and everything. It can really add up. So if you have the ability to sit down with the franchisee and have an amicable discussion and reach a resolution outside of what is, the court system, it's a lot more straightforward and it will save you a lot of costs in the long run. And this is also the same when you think about your customers as well. You may want to include provisions in the franchise agreement that ensure matters must be addressed within certain timeframes. For example, by having a meeting together before going to court. This is generally quite helpful, we find, and a lot of standard contracts that we draft at LegalVision include this type of provision where it says that if the parties are in dispute, they have to sit down and attempt to talk through the issue before taking any, urgent action under the franchise agreement or under the agreement itself, just to try and avoid that dispute process through the courts. If you are a FANS member, one thing that they have set out in their codes of practice is what we call like an alternative dispute resolution procedure, which is a mediation process. We generally recommend including a clause like this in most franchise agreements anyway. The FANS code of practice, their process is actually the franchisee and the franchisor come together and try and have a mutual negotiation. If that fails, then there is a mediation. And then if that fails, we go to court. So most franchise agreements we see contain similar provisions to that anyway, and it's usually a pretty good first step. And then like I mentioned earlier, where appropriate, we always recommend alternative dispute resolution processes unless there is an issue of major concern. So things that might fall out that's outside of that scope would be if you're the franchisor and the franchisee has stolen intellectual property or is, maybe misrepresenting the brand in some way, there may be an opportunity or you may need to go through a more formal court process in order to get some pretty quick action against the franchisee. And then finally, Rebecca is going to just speak quickly about privacy obligations.
Now, if you're a regular watching LegalVision webinars, we do talk about privacy quite a bit, and it's for a really good reason. If you are operating any business in any kind of way that you are collecting information, which is as simple as an email address, then you are subject to privacy laws, and you must ensure that you are compliant with them at all times. The most important thing is that it's not just New Zealand law you need to be compliant with. if you're operating in any other jurisdiction, your customers are from any other jurisdiction, or your possible franchisees are from another one, then you need to comply with the privacy laws of that country as well in most circumstances. The most comprehensive of this is from Europe, which is a very long, fancy one called the EU GDPR, which has some real enhanced obligations on you as the collector of information as to how you store, release, allow them to edit. So making sure that your privacy policy is really comprehensive and that it's well understood by everyone involved in your business is important for that compliance matter. Then we also have the need to possibly add in a collection notice, which is if you are collecting sensitive information, especially about your franchisees in that application stage, you might have access to things like their credit information, which will hold you to a slightly higher standard as well. So even though we talk about it a lot, and I'm sure lots of people are privacy, it is something that is very easy to breach and the consequences are high, and it's not something we like people to overlook. So having it standardized and in place early on will really help your business out. That's everything that we have on our contents to discuss today. So we hope you found the webinar informative. You might also find our free publication, the Franchisor Toolkit for New Zealand, available. You can download that from the handout panel. We also have some upcoming events that may be of interest to you. So we have Navigating Dispute Resolution, Tips for Businesses, which I'm sure pretty much everybody could benefit from. And that's on Tuesday, the 14th of May at 12 p.m. New Zealand Standard Time. So you can register for that on the link there in the slide. And obviously these slides will come to you after the session, so you can navigate to it from there as well. We're going to answer your questions very, very shortly. While you submit them, we'll take a minute to tell you about LegalVision's membership. So by becoming a LegalVision member, your business gets unlimited access to our full team of over 100 specialist lawyers for all your business as usual legal needs. It's like having your own in-house counsel for a fraction of the cost, and our team can assist you with the unlimited document drafting and reviewing of business contracts, unlimited legal advice consultations, which can be really reassuring, and unlimited domestic trademark registration, and so much more. You also have options to purchase extra credit towards things like complex matters, ongoing disputes, which do happen, and these are charged on an hourly rates basis. If you want to learn more about how membership could help you, you can request a free consultation when the survey ends at the end of this webinar. So now we have some of your questions, so we'll just check to see what we have. So one of the questions that's come through, which I think is really, really pertinent, is at what stage do you actually engage if you're going to take on legal advice before starting your franchise? Obviously, as lawyers, we always want you to engage us as early as possible, depending on your structure. If you're with someone like LegalVision, there's no harm because you have unlimited consultations. We can have a chat at the beginning, maybe a strategy session. If you're in a more traditional legal environment where you're paying per consultation, I still recommend having one upfront sort of strategy-based session where you can set out that entire framework of how you're going to tackle setting this business up. And then you can sub your lawyer in as you need to with the areas you're struggling with a little bit. But it does depend. Corinne, did you have any opinion on that?
Yeah, just aligned with what you've said. Very important, as soon as possible is what I would say.
See what else. Yeah. So this one might be a little bit more for Corinne, but I have some thoughts, which is around what happens when you want to operate in more than one country. So it's really common for us that we have some questions pop up with our clients in particular, because LegalVision's in Australia and in New Zealand, that sometimes they would like to expand across the ditch one way or the other. And I'll let Corinne take over what you need to be thinking about if that's going to happen.
Yeah, so it's really important to remember that franchising laws are based on based on the countries that you're operating in. So every country has different laws around that. So New Zealand is, I guess, like a bit of a dream place to franchise in a way when it comes to franchising regulation, because there's not a lot of regulation there. Like I said, there's fans, but it's optional. You don't have to be a member. So as far as compliance, you're really only worrying about those contracts that you're signing with those franchisees and your consumer contracts from a, actual consumer law and all the employment law perspective, everything that Rebecca's spoken to today. If you look at expanding overseas, be mindful that there are different countries with different laws. So an example, I mean, I'm in Australia. So Australia has really robust, really strict franchising laws. There's a whole code that is not an opt-in code, it's a compulsory code that governs everything we do here. So some people, when they start in New Zealand, are like, what does it look like if I move to Australia, being, the closest neighbour? It's a lot more different. That disclosure document that I mentioned that fans ask you to have, that's a compulsory document in Australia, for example, along with a lot of others. So keep in mind that if you've got a model that works in one country, it's important to test whether it's going to be successful in another market and in another country. And then also keep in mind what that looks like from a documentation perspective. Generally, we recommend that you can have your baseline documents, so those franchise agreements that we draft for you, but you would probably need them localized by a lawyer in the relevant jurisdiction. So while they are good and they may work, they probably won't be fit for purpose in every country. So keep that in mind. Obviously, test that market and make sure that you're comfortable, and get advice from lawyers within the specific country that you're looking at expanding into, is what I would say.
Yeah, I think definitely the thing that we've noticed over the years has been start small, test early. You can make iterations if you need to, especially because beyond the franchising documentation, in that commercial documentation space, consumer laws change in every country that you're in. And that can really, and licensing, like how are these businesses operating? Do we need to have everything approved by the local regulatory bodies? It's such a nuanced thing when you venture out into a new jurisdiction that you really need to make sure that you've thought about it and that you've done the sort of risk assessment as to whether or not the pros and cons for your business are worth it before doing it. It is possible. I don't want to put anyone off, but it is something to be careful of.
Certainly.
All right. Those are the only questions that have come through. Obviously, if you do have other questions afterwards, we do have the free consultations about LegalVision membership, which you would be able to do. You can book in your complimentary consultation after the webinar ends. A survey will pop up, and we would appreciate if you could answer the survey, regardless of whether or not you would like to have a consultation or not. But if you want to have that consultation, just pop your contact details in so we actually know how to reach you. And it's been an absolute pleasure talking to all of you today.
Yeah, thank you.
Thank you so much.
Thanks.